Yeah.
Okay.
The judiciary one hasn't changed as I understand it.
I want to make sure with the judiciary one that there's funding. We're going to hear from the Office of Child Support and their concerns about magistrates, and also from the trial lawyers, the Vermont Association for Justice, regarding the 6-member jury's possibility if both sides agree to allow 6-member juries. That was something that they brought up earlier to the committee a while back. And then I want to make sure that I want to make sure that everybody is not asking for base funding. If you are, you're in the wrong place. We don't have the base funding money. That's not. I just don't think that's possible. Okay, so we have a letter from the state's attorneys. Good morning. This is Senate Judiciary. It's 11:15 or later, and we're taking up some appropriations. I apologize to all the folks who are here, but I ask you to be as brief as possible. Annie, do you want to handle this, or do you want John to take over for the state's attorneys?
Thank you, Senator Sears. I think John is going to start, and I can help with any details on the
numbers.
Yeah,
we need to go through this rather quickly.
Okay. Thank you.
Andy, why don't you go ahead then, just go ahead and take it through. But if I could just start just to say, Senator, this is in response to the judiciary's plan that they put out. So we had to go back through and revamp the whole thing. So that's what this is in response to.
Great. Okay. Good morning, Senators. Thank you. So if you, Peggy, I don't know if you want to put up the document that was sent over earlier this morning, so that if that's how I don't know if the committee prefers it that way.
Would you like me to do that, Senator Sears?
Yep.
Okay.
Fine.
All right, give me 1 second here.
You're asking for $9 million.
Guys. Can you see that?
Right, great. Thank you, Peggy. Peggy, could you just scroll in terms of this? Would you mind just scrolling down to the chart? Thank you very much. Thanks, Peggy. So what you'll see in front of you is requests, and this of course falls under the ARP money, and that is why you will see it running through to FY25, and you'll see that FY25 is just a half a year. So it basically looks for 8 deputy state's attorney prosecutor positions for caseload relief during a period of time. I costed all of these numbers out with salary and benefits as limited service positions. Limited service positions in state government provide for health insurance and retirement, and basically the benefit package. So if you look at this, you'll see it go across for the period of time that would allow us to use the ARP money. The second column is really only in response to Judiciary's comment about that they may open up for nights and weekends. If that were to occur, we would look for 1 additional prosecutor per office to handle the night and weekend court. If that does not happen, then we would not be looking for that money. That's
just why would you need an additional prosecutor in the counties that don't even have a full-time prosecutor?
So our thought really is it's to pick up the caseload for that schedule. We have a
but you're putting this is what doesn't make sense. You're putting maybe John can answer it. You're going to put 1 prosecutor in Chittenden County and 1 in Grand Isle County.
And Senator, what we did was we did it per office. And again, I think that in order for us at central office to be fair to all of the offices, we do have two part-time offices. So I'm assuming that would be taken into consideration, and that could be.
Well, you might need 14 positions, but I don't know if you need 1 additional per county.
Right.
Okay. So if that does not occur, that number would come off the bottom line, and I did run both numbers below. Two
Yep.
IT positions, the expansion of remote hearings, the integration of our systems and the technology. I do just want to remind the committee that the department here serves basically the 14 states attorney's office and the 14 sheriff's offices, and we have one IT person, Al Kakanya, that's it. And so it's Al is addressing IT issues for 170 employees, including all of the issues that have come up with the new court system. In terms of being able to address what we think we need, those two IT positions would help our staff out in the field to become better able to manage the IT issues, remote IT issues on their own. But in addition to that, it would give us an opportunity to give him some relief during the period of time where we have to transition into a different system. So the costs of that, are basically sort of at a tech level, and we think that it's appropriate under the ARP money because it really does serve to address the remote issues. Administrative support, these would basically be staff people in the offices to help out with similar things, but really more in terms of the work that's come about as a result of the judiciary's new system, which we are not on, and we are trying to manage getting our documents to that system. The workload caseload study that we've done with some of our key admins really does show us that the work shift has been tremendous to our administrative support staff. So we've written in for help for them.
And if I could add on that, is that dealing with this backlog is going to be just an incredible pressure and exacerbate the situation that we already have. So that's again one extremely important aspect of this request.
Thank you.
The victim advocate coordinator, we have 27 victim advocates scattered around the state in different offices. We don't have a victim advocate coordinator. And one of the things that the victim advocates have most asked us for is to have someone assume that role. We would like to try to start the position here under the ARP money. And if successful, we would then at some point down the road look to ask to build it into our budget several years down the road. But if we can get the ARP money to start this, we can see the success or the positive. We can see how this would work and how the victim advocates would use this position to support them in their work.
And this would also be tied to the backlog, because once the backlog opens up and once we start going to trial, we're starting to having to come up for trial conferences. It's going to be essential for the victims advocates to have to reach out to the victims, family members, a multitude of issues. So their jobs are just going to, again, just like the administrators, it's just going to be exacerbated by the opening of the courts.
And that would be the same for the next John just explained in terms of the victim advocates themselves. We're looking for 12 victim advocates under this money. And again, for the same purposes that John just mentioned, the reach out to the victims and the families and helping them with all of the paperwork for restitution or compensation, and just explaining the process, the court processing to them and helping them feel that they are staying safe and aware of what the process is for them. So if you look at the total number here down below, you'll see that it looks at $10,932,000. If we take off the nights and weekends work, it goes down to 9.5 million. Oh, I'm sorry. Excuse me, Senator. I also included some equipment and desks and some. I don't know if we would actually have space increases.
Actually, I think that would be more into a different pot of money.
Yeah, I don't think. Yeah, it would be through the internal service fund.
Infrastructure type.
Yes. Yep.
Money.
Yep.
Stephanie Barrett,
So it's, let me turn on the. The infrastructure, this isn't really infrastructure, desks and office equipment. It would be out of the same ARPA pot.
Oh, okay,
It wouldn't be like capital type money.
Right.
okay.
And actually, Stephanie, it might be that this would not necessarily go here if the Internal Service Fund was able to provide it to us. We looked at what we might need.
You mean fee for space type of?
Yeah, right.
No, it would still come with a cost. The Internal Service Fund itself can't cover it. That's a zero sum game in the
Okay.
Internal Service Fund.
Okay.
It would be helpful to distribute, is the 1.4 an annual number for the 14 positions?
No, that was the total.
Okay, so it would be helpful to distribute that over the years and then to subtotal the years.
Okay. I can do that. Thank you.
Okay, any questions for Annie or John Campbell? Thank you both very much.
Thank you, Senators.
Next, we have Matt Valerio, the Defender General.
Good morning.
Morning.
We also submitted something this morning.
Yep.
And
Yeah, it's 4.6 million total. Over.
right, and if you scroll down to the bottom, that's where the money is. Again, we are submitting this in response to what we saw in the Judiciary's proposal. We, in a canvassing of the public defense offices, and I had a managing attorneys meeting the other day, a couple days ago. It appears that there is some potential backlog in a couple of counties, but interestingly, the vast majority of counties don't see a major backlog, but are more concerned that just being able to deal with the technology and open and address what has been stagnant, for the past year. What I mean by that is that it seems that filings have dropped, and unless there is a huge increase in filings going forward, but for a couple of counties, they think that opening the court full time and having normal access to it will resolve a lot of issues. That having been said, in the event that there are more judges and more prosecutors available to do more cases, we propose to keep in place the public defense caseload relief contractors that we put in place this past year to deal with cases. We put 7.5 people spread over 7.5 full-time equivalent contracts, and those are spread over the entire state. When we do these by contract, of course, we don't have to deal with benefits and the costs that apparently state's attorneys have to deal with whenever they put a person on. So our number is significantly less. The biggest issue we're running into is addressing IT support for the people who are out there. And so we have asked for a couple of IT positions that would be spread over. And again, these are spread over a 3.5-year period, and some administrative support to assist in the processing of cases through the Odyssey program, which seems to have significantly increased the amount of work that is put on our admin folks. Again, if we're processing more cases by virtue of more judges and more court time potentially, then that's going to be necessary, we believe. The other things that we're asking for are relatively small. For those people who did not take advantage of the IT upgrades that we had last year. I mean, we put a fair amount of money into that last year, but I think there are some outliers and lingerers who didn't have the opportunity to get their systems, or didn't understand how that they had the opportunity to get their systems upgraded so that they could do video work and work with the courts, a new system. And so we're looking for that both in assigned counsel and in public defense. And then again, just some basically workspace furniture and the like. We're 10 grand for those individuals. So we're in at 4.6 million over the next 3.5 years. You can see how it's spread out. And we didn't put anything in for proposed nights and weekends because I really need to know if that has anything to do with public defense at all. I mean, the courts could just be doing, divorces and foreclosures and evictions after hours, and that would have nothing to do with us. Or depending upon how it was scheduled, we could have, we have existing contractors who are willing to do that work. I talked to our people about it, and they, while clearly it's not an ideal situation, they were particularly concerned about getting cases, getting clients out of jail and getting cases moving. And if that's what it took, they were willing to do it. There are some individuals who may not be able to do that because of kids, responsibility with children and family and that sort of thing. But for the most part, there wasn't a huge pushback regarding that. Weekends clearly were more of an issue, but the extended hours by the courts were not met with a huge amount of pushback, and it's something, if it was scheduled, in a way that accommodated them, it is something that we could handle for a period of time. I don't know. I'm guessing that it may cost some money, but I can't even guess as to what that would be until I see what the plan is. And so I just left it blank. I didn't put zero. I didn't guess.
I think we can assume there'd be a cost, but you're correct. There hasn't been a clear message yet from the judiciary whether it's really part of their plan or not. At least the last time that I talked to Pat Gable, it seemed like she just mentioned, I think it was in appropriations, Stephanie or any member of the committee who's on approach can correct me. I think she was saying she was getting a lot of pushback on it.
It was in here.
It was in here.
We have some folks who did this, have worked in New York and in Boston and other areas where they do night court and that sort of thing. So it wasn't unfamiliar to them. And, again, it's not preferred, but it's also not impossible. And I think that, we could work with it if necessary. I mean, I prefer, honestly, that they do foreclosures and evictions, but, because there's going to be a backlog of that as well.
Yep. Well, it'd be a backlog of that, a lot of other things. So are there anything further, Matt, that seems total? And I like the way you've totaled up the columns there. So we're talking about a certain amount for 22, 23, 24. Any questions, Stephanie, on this one for you?
I had sent out a question to Lori. I just wanted to be clear that the House budget had increased the base in the Defender General's office. And I wanted to be clear that this is on top of that increase.
That's correct.
Yeah.
Yeah, the amount that was over the governor's recommend actually just keeps in place what we had already had in place from our base from last year, not CRF funding. So It accommodated raises, it accommodated, contracts that we already had in place and struggled to, to make work. But, we saw some downsides in other personal services with no trials and that kind of thing that would allow us to, do what we did. So anyway, yes, this is on top of it. It's separate and apart.
Thank you. Okay, thanks, Matt. Appreciate it
Thank
very
you.
much. Chris Maley is here. He's an attorney representing the Vermont Association for Justice. You've already heard the Defender General hopes they make you work at night rather than this group. So anyway, any comments that you have on the judiciary's backlog proposal?
Thank you, Mr. Chairman, and members of the committee. I appreciate the time being heard on this issue. I'm preaching to the converted a little bit, so I'll be pretty brief because I'll refresh the committee's memory that I was before you all in late January, and on behalf of my clients and the Vermont Association for Justice, the ask was to strongly push and respectfully push the Supreme Court to issue an order for juries to be conducted with 6 jurors instead of 12. At around that same time, there was a jury restart committee that was made up of attorneys on both sides, plaintiffs and defense, and 2 Supreme Court justices, and they unanimously recommended that civil trials be ordered to go forward with 6 jurors when it was safe to do so. And then the committee, after I testified, Senator Sears authored a letter on behalf of the committee that did strongly and respectfully recommend that the Supreme Court issue this order. And it laid out a lot of the arguments that the plaintiff's bar has made about it being safer, about it being more practical, about putting less bodies in the court, and about it being a way to save resources going forward to undo the backlog in the civil justice system. And unfortunately, the Supreme Court issued an order on April 8th that was quite disappointing to the plaintiff's bar. It basically said that the chief of the Superior Court has the power to order courts to be transferred to different courts that are safe when they're ready. But then it had a statement that said the Supreme Court encouraged civil litigants to agree to 6. Well, the practical effect, with all due respect to the Supreme Court, is that that's not going to change anything because there already was the ability to agree to 6, and that wasn't happening. And I've had the practical experience of getting that order and then asking defense counsel, will you agree to 6 now that the Supreme Court has gently suggested that you do that? And the response was so quick on my email back, no, that I didn't even feel like they had a chance to read it. So I think that we're still in the same place we were in the end of January, where the plaintiff's bar really thinks that that is the practical and simple solution. Not that it's going to solve all the problems, but it's one way to get things going forward. And that when we're at an appropriations discussion, and we appreciate the work this committee's doing and everyone on this call is doing to try to figure out the best ways to use the resources to get the systems going, that we think that there would be a less of a burden on the civil system if there were 6 jurors. Now, since I testified, Massachusetts has ordered exactly what I had hoped Vermont Supreme Court would do. Their Supreme Court said last week that despite the fact that civil trials in Massachusetts in Superior Court used to be with 12 jurors, they now should be going forward with 6 for all the reasons that we've described. So all I can say is that we're still in a very precarious situation with our backlog, and I know that the criminal justice system is making a lot of asks in terms of resources, but I just hope the committee will keep in mind that the civil justice system is in a similar bind. And so while we don't know the specifics about what the judiciary needs to get trials going, we want to encourage this committee to get all the appropriations necessary for trials to happen. That is really the key to get our system going now. Cases don't resolve when there's no leverage or deadline or imminence to the end of a case. We're really in this sort of never, never land, and we have been there for a year. And that means Vermonters waiting for access to justice. And so we appreciate the committee's support on this issue, because they've already weighed in. You weighed in exactly the way we wanted you to. And so we're just going to keep pounding the drum on this idea. And maybe there's another way to get to that 6-juror solution.
There had been some discussion in appropriations and judiciary about how far we can push, given the separation of powers issue. But certainly if money's appropriated, there may be some ways to put some language into that.
Appreciated.
But again, that really is there. One of my other concerns is that they've adopted for a number of counties to start up jury trials, but not Bennington and some of the other counties that don't have the facilities. And yet we have 3 courtrooms in the state office building that could be used at the same time with retired judges and so forth to clear up, for example, eviction notices, clear up a lot of the backlogs. So you've got 3 courtrooms. They just need to be outfitted properly. Thank you, Chris. Appreciate it. Any questions for Chris or comments from the committee? Or Stephanie, do you need anything on this one?
I don't think so.
Okay, thanks, Chris.
Thank you.
I'm going to jump to Robin Arnell. There is a document from Robin, and I got a call the other day from Commissioner Brown of the Department of Children and Families talking about a real problem for the Office of Child Support and the backup. So Robin, welcome to Senate Judiciary. It's been a while since we've had you. And you and Sarah Hazelton are joining us remotely. And then we have one witness from the state, the Vermont State Employees Association.
Thank you. Thank you to the chair and also to the committee members. And you're right, Senator Sears, it's ironic. I think the last time that we were invited to, or myself was invited to this committee was, I think 2008 or 2009, and you had concerns about the Great Recession.
Right.
So here we are. So I really appreciate the opportunity, because I don't think a lot has been said on behalf of these families that are kind of stuck in this backlog. We're hearing a lot about the backlog, but we really want to walk you through the data and to show you what we're seeing and what we've been tracking over the last several months. I'm going to spend a little bit of time on that. And then I'm going to hand it over to Attorney Sarah Hazelton, and she's going to walk through from that analysis of what we're seeing, like what we're thinking would work the best for this particular backlog.
I will remind you that we're on a real tight schedule this morning,
Yep.
Robin.
Okay, I get it. I understand. But we're talking about 2,500 families basically that are caught in this net. If we could move to the first slide, please, or second slide. They are basically over 4,000 households with kids who are seeking some sort of financial relief. Just so that you can understand and put it in context, the data is that we, at a very high level, I'm sure folks know that we are in the business of assisting folks who need a child supporter, helping them maneuver and navigate the court process so that they have an order established. And where we have folks that have an order, we're tracking those, bringing in payments, and when those payments stall or they fall because they need a modification of that order, or we need an enforcement, then we're taking those cases and we're bringing them into court. What folks may not realize is that over the last several years, we have been moving in a direction where we have shifted what had been more of an enforcement-focused model to one that's more non-adversarial and family-centered. And actually, Senator, since after that 2008, 2009 initiative, which you helped bring about, we have been able to do a lot in assisting all types of families. Parents who are paying parents, we're helping them get their orders into court, having them right size, as we say, and having them modified. And obviously, a lot of our folks, there's no means tested threshold for folks to get our services. And certainly have a lot of folks that are, we have some folks that are receiving, six-figure salaries, but most of our folks are low income to moderate income folks. They need that child support to make their bills, and certainly they're pro se. They don't have the means to pay for an attorney, and so we're helping mostly those folks get their child support addressed in the court. So if you can move to the second slide, please. This is not a surprise to anyone. After the governor came out with a stay-at-home order, his emergency order, life changed for so many of us. Several hundred cases were taken off the docket, in one fell swoop. It took us about a week and a half to get everybody set up to work from home. And the first thing we did is we asked that our paralegals, our caseworkers, our attorneys reach out to all those folks and see if there was any way that we could get an agreement or a stipulation together so that we could move that case forward. And obviously, the difference between March 1st and March 31st for some of these people was massive. So if you were on the docket for an enforcement, for example, and they've lost their jobs, then the situation had changed. So let's go to the next slide. And when the court did reopen, it was understandable there was a very, very different process that they had to employ with different protocols with COVID. And additionally, they had the case management system that they were rolling out. They had to close down, a couple of days to train up staff. And then there was a lot of adjustment time, and they still have to have an adjustment period. They're working with this new system. So what you're seeing here is what I've called I've separated into between the court pipeline and the OCS pipeline. What you see right here before you this is data that we finally, after we were in this period of free fall, we pulled together, and we felt that if we started tracking certain things, it would help us figure out how we needed to respond. So this is 6 months worth of data. The red column are those cases where we've already met with one person or both parents, and we have put together the paperwork. We need a court order, so we've filed it with the court. That's in the red column, and we're waiting for the court to process that paperwork and schedule it and put it on their calendar. So as you can see, as we move from October to March, very little movement, between October and February. We're starting to see a little bit of a movement in March. The amber colored column represents all those cases that had been in the red column waiting to be processed. The amber colored column are the cases that have been scheduled. And then the green represents all of those orders, because we want to kind of measure what's in and what's going out. And obviously, the more green we have, the better. We're tracking those actually manually, and you can see there's been a little bit of bump in March, but I get those reports every week, and unfortunately, the last couple of weeks, we've been getting, I think last week was 55 orders, and the week before that was 53 orders. So I'm hoping that it's going to bump back up, but I'm just, I want to share that with the community, because I do have some cautious optimism there. The other thing I think it's really important to note is that red column represents almost 50% of it, 3 counties. So that would be Chittenden County, Bennington County, and Rutland County. So that's where we're seeing right now the pain points. We work closely with the Court Administrator's Office. I meet with Terry Scott on a weekly basis. She's been great about recognizing the needs that we have, trying to get cases scheduled. But we are struggling mightily with Rutland, Bennington, and Chittenden counties. And so what you have in those red and amber columns, these are cases where possibly there's stipulations that we've filed, because in order for us to move forward, even if we have an agreement with parties, we still have to get the court to review that order and sign off on that order. And a lot of those cases, I must tell you, you're probably not surprised, are cases where someone's lost their job and we have to modify that order downward. And some of these cases are folks who have waited weeks and weeks and weeks. The court will oftentimes go back.
This is a lot more than I expected. And I wish I had scheduled more time. I didn't, unfortunately, and I don't want to. I've already, the committee's willing to go to 12:15, but we've got another witness. So I really need to give that.
I understand. So
I don't know if we need to come back to this tomorrow, build in time tomorrow on the agenda.
I can quickly run you through if you just give me maybe 5 minutes. Okay.
5 minutes would be great.
Okay, so go to the next slide, please. So once you get an assessment of where we are, then what we did is we looked at, okay, what does it look like pre-pandemic? How long does it normally take the courts to go through these cases? And this is what you're seeing. This is based on the court's own numbers. In a new case where you're establishing an order, this is how long it's taken in the average number of days by county to get an order from the beginning, from the filing to the date that you get the order. So this is the establishment cases. The next slide, please, and then this will tell you how long it normally takes for a case that needs to be modified, how long it takes in each county to get through the system. And then the next slide, please. And then enforcement, the same. Obviously, right now, we are trying not to, we're prioritizing our cases, and we are doing whatever we can so that we don't have to file anything with the court. Next slide, please. And quickly, and if the committee would be so kind to have us back, we can get into this in more detail, but I will hand this over to Sarah.
Thank you, Senator Sears and the other committee members. So we had approached recognizing that this backlog was not soon going away. Representative Maxine Grad, and she did propose back on March 9th, short form bill H389, which is an effort to help reduce the backlog through expanding OCS's administrative processes at no additional expense to the state. While this project initially, that as contemplated and drafted, was an expansive bill that would be statewide, we certainly recognize that there's a limited time in the session and that there may not be time for a large policy initiative. But what we do believe might be possible is to look at piloting this project and process through those counties that, as Robin mentioned, show the most drastic results in terms of the backlog. So specifically Chittenden, Bennington, Rutland. Certainly, I believe an administrative order would accomplish this endeavor. What we're trying to do at the end of the day is improve and stabilize the financial situations for these families. As Robin said, there's 2,400 cases currently in this pipeline that are just waiting. And given what those statistics show that she referenced about how long it takes in Chittenden County pre-pandemic, 297 days was the average to obtain an establishment, an order. So if you could please move to the next slide. So what we're contemplating specifically under this endeavor is expanding OCS's administrative authority. I should note we already have administrative authority to do very complex and certain administrative functionality, things like trustee process, bank liens, etc. That is already permissible pursuant to our current statutes. What we would like the committee to entertain and make recommendation about is expanding that authority to allow OCS hearing officers to handle more perfunctory matters so as not to clog up the court system with those simplistic matters, and reserve hearing time for the things that are more complex and really should have a magistrate or judge's discernment. So what we're talking about is stipulations. And very preliminary data we've looked at in one region alone, it's taking more than 30 days on average to run a stipulation, an agreement through the Odyssey system. We're also talking about expanding this authority to straightforward modifications in establishments where there's W-2 verifiable income. And then finally, for things that are really primarily focused for OCS accounting needs, things like motions to stay in escrow when we've had a change of custody or a change of payee, affording us the ability to just stop that order so that child support is not being deducted from the parent who is no longer the payer, but may in fact be the payee. Finally, I would note that the judiciary is no longer even setting review hearings on a program that we have, which is called Work for Kids, which is really an employment services program. They just don't have the bandwidth due to the backlog. So we would also be contemplating a system that would allow at least an initial review to assess individuals' compliance with that program with us. As proposed, we would ask that these hearings be conducted by OCS attorneys who are duly qualified, at least 3 to 5 years of relevant child support experience. The evidentiary standards would be those that apply also before the family support magistrate, and it would be a de novo appeal in the event that someone disagreed with a decision that issued before the family court magistrate. So certainly it would be an issue of first impression that the magistrates could decide if they didn't agree with any decision that issued as a result of the hearing officer's decision. All orders that would be issued as a result of this process would further be filed with the court so that they are certainly kept in the loop as to the process and to any orders that issued as a result of this procedure. Again,
I need to break there. I really appreciate this, but it sounds like this is a bill that would need to pass. It needs legislation to allow the pilot project to happen. Am I correct?
I think legislation.
I don't know who's drafting OCS stuff in Ledge Council, but I would need to schedule this for next week if I can, and if we can even do this. I'm sorry, my communication with Commissioner Brown, it didn't lead me to I thought you were asking for money today
No.
to try to clear up a backlog, and what you're actually asking for is legislation. And I wasn't aware of H309. We're not allowed to do short form bills in the Senate, so I wasn't even aware of that bill. But we need to find out who in Ledge Council handles Office of Child Support Matters.
It was Michelle Childs,
and Michelle.
Yes.
And discuss whether or not we can take it up next week. I don't think this is a little more complex than I thought it was going to be, and I really apologize to both of you. I appreciate the problem. It's unfortunate in my communication. I didn't realize.
Well, we appreciate just having the time, and like I said, I think it's a story that's not getting out there.
Well, definitely a story that's not getting out there, at least to me, and I think the members of this committee. So if we have time next week, we'll try to understand this issue a little better, but it sounds like it's something that needs emergency.
You know, and we're not naive.
I'm meeting with, and I really need to get going because we're already past, and I've got another meeting at 12:30, and this is
Appreciate it.
the glory of Zoom, is that we keep pushing ourselves in ways that we shouldn't be.
And
Thank
Senator
you.
Sears, I have one at 12:15 I have to be at.
Yeah, so we're gonna try to, Christopher has been waiting, and I can't pronounce your last name. I can't see it. So please introduce yourself and welcome to Senate Judiciary.
Thank you, Mr. Chair, and thank you to the members of the committee. My name is Christopher Lukasik. I live in Brattleboro. I work as a victims advocate with the Windham County State's Attorney's Office, also in Brattleboro. I've been working there for about 5 years, and I currently serve on the bargaining team for our unit within VSEA, and that's where I'm coming from in my capacity there. I just want to briefly go over the Department of State's Attorney's proposal and provide support for their entire proposal, but I'm going to hone in on the Victim Services Coordinator, the proposal for 12 victim advocates and 14 administrative assistants. So I want to provide some background about why that coordinator is important. And this has been, for years, as long as I've been working here, a big ask among the victim advocates. And the biggest thing is that we need a state employed person who is only focused on the delivery of prosecutor-based victim services. And that person being the relationship builder between the 26, 27 victim advocates and other partner agencies such as the network, Disability Rights Vermont, Court Diversion, et cetera, et cetera. It'll allow those programs better access into the victim assistance program and allow better collaboration with community stakeholders. The coordinator needs to be a policy translator so that they can keep an eye on legislation that's going on in this committee, in the House, et cetera, and provide that boots on the ground education, both to the legislature, but also to the victim advocates about what the changes are going to look like. I know I think it was last week, there was comments about a negative reaction from the victim advocates based on some legislation that this committee recently passed. The goals are very clear with the legislature in passing those bills. I personally support those bills, but the reason that negative reaction occurred is because no one's providing that legislative education to the victim advocates. And personally, I didn't learn about the Senate passing the expungement bill until my state's attorney actually talked to me about it. And that brought me to talking to VSEA about it. It's also important for someone to stay on top of new knowledge in the victim services profession and staying involved in national conversations, what's going on in research, all of that, and providing that education to advocates as well. Specifically addressing the backlog, the coordinator can do needs assessment work among the victim advocates, meaning that from the bird's eye view, from the statewide view looking down, we can be identifying the offices that need more assistance, figure out best practices, good guidance to get them that assistance, which is a good segue to my next point. So the department is asking for 12 new victim advocates, as well as 14 administrative assistants. I can tell you right now, where we are currently staffed, the 26 workers in 14 offices, 27 when we fill the vacancy in Essex County. Right now, it is unsustainable. We cannot manage our caseloads because of the increased backlog, and that the 12 victim advocate positions that the department is asking for will greatly relieve that the burdensome caseloads. And burdensome is used very lightly, because when I'm talking burdensome, I'm saying there are advocates carrying 700, 800, 900, even more active pending cases in their county, and that is just astronomical, and it's just horrible. I know that the Center for Crime Victim Services and Chris Fenno has put forward a idea for a study committee, and I need to make sure the committee understands that I believe that VSEA needs to have a seat on that committee. Even if the committee does move forward with supporting the 12 victim advocates in the limited service request, I think in general, the committee needs to place VSEA onto that committee if this committee has that power to do so.
I'm not sure
Essentially-
which committee that would be. I don't know what committee, or I don't know. I need more specifics on the bill. If you could just send me some information, or the committee some information when you get a chance.
I absolutely can do that, Mr.
What's
Chair.
the number of the bill?
I am, unfortunately, I do
He'll
not
get
have
it.
that.
He'll get it to us.
Okay.
Yeah,
I'm sure Vince or Steve Howard could help.
absolutely. I have something in my email, but it'll take me a second
Yeah.
to locate
No,
that.
no problem. It's not
Yeah.
a problem.
Essentially, just the core points of my testimony today is that these caseloads don't allow for us to do what we want to be doing, which is the person-centered work. And that's talking about prosecutors, that's talking about defenders, that's talking about victim advocates, that we're trying to hit the needs of all stakeholders in a criminal case, and these types of caseloads cannot allow for that, do not allow for that. And I always say, I frequently encounter victims of crime who have the ability to take the steps they need to take to meet their own needs. And I equally encounter victims of crime who have that reliance on me to connect them with those services. And there's no one good way of figuring out from the get-go how those conversations will look. It's in the moment when I'm on the phone with someone that I start to identify the need of, oh, I need to take my own steps to help this person out, rather than them doing it on their own. That is the core of my testimony. So
Well, I appreciate your perspective, Christopher. I want to mention one thing. But over the years, we've had a number of people who work for the Center for Crime Victim Services who work closely with this committee. Kara Cookson was the last person. Her position wasn't replaced, and I wasn't aware that victims advocates weren't being heard on different bills, because I was told that Chris Fenno was going to take over that role, and she does frequently meet with this committee. But I had wrongly assumed that she was coordinating with victims advocates on the bills, or that John Campbell or whomever from the executive office was doing it. It seems as that's one thing that we need to address in the next session. Obviously, this is pretty close to being over, but you're not getting the information that you need on bills so that somebody is recommended. The second problem with victims advocates is that they have a tremendous job, and I really appreciate all you do, but because it's funded through a grant through the Center for Crime Victim Services, that does complicate matters when we're looking at these. But I think that the Appropriations Committee has heard from John Campbell and others about the need for a coordinator. And that, while it is looking like in this proposal it's funded for 3.5 years, it probably should be a permanent position, and the importance of that, being able to have that, whether or not, base is very tight, but as you know. I do want to comment on those two things, and I thank you for being here today.
thank you for having me, Mr. Chair.
You're welcome. Committee, I think we're going to take some time tomorrow morning to mull over if Stephanie can be with us at 11:05 tomorrow morning. And Bryn or somebody from Ledge Council who could draw up something on the 6-member juries that we can do without violating the separation of powers. Peggy, we would cancel the 11:05 testimony and put it off for another future meeting.
Okay.
Bryn, would you be handling that? Did you handle the 6-member jury, or? Was that Eric?
No, Eric did that, and I'm not available tomorrow morning at 11, but
Okay.
I'm sure one of us will be.
Well, I think we had Eric here.
Actually,
anyway.
Eric's scheduled,
Yeah.
so that would be,
Okay.
is that work for you, Stephanie?
I think Stephanie's not on anymore.
Oh, okay, maybe we could check with her to see if that'll work. And who does
Senator
the
Sears?
office, who does the Office of Child Support? You do?
So normally, I think that it's split between Katie McLean from our office and Michelle Childs.
Okay.
So I can be in touch with them about
Can you,
that issue.
yeah, ask them to get in touch with Robin about their proposal. It's on our website, on our webpage in today's. So if there's something simple we could do, would love to address that.
Dick, I'll see you at 12:30.
You
So-
have to leave, Senator White?
I do, but I was just going to say that we took a lot of testimony around in GovOps about what counties needed. And we're recommending 12.6 million to get the county courthouses HVAC so that they can actually get started. And we thought that that money could come from the 121 million that's designated for counties. So just so that I sent that to Jane.
Okay, thank you. I think one of the problems is that when the administration and the House went over the bill, they thought there were no counties, so they just sent it to the towns.
I know they're going, and we're asking if that's a federal issue, and we're asking our federal delegation to come to the support of our
That's it.
counties. And-
Yeah,
And if it's a
They-
Vermont administration thing, that's ridiculous.
well, I believe that's what, and I can stand corrected by Senator Nitka, who's still on.